Paul Whalen with a Ford Law. At a Ford Law, we practice criminal and family law throughout Massachusetts. Today, I'm just going to talk about bail revocation in Massachusetts. What is bail revocation? Well, what happens is when you get arraigned, and the arraignment is the first official step in the criminal justice process. That's where you're brought before the court, before a judge. The judge or the clerk tells you exactly what it is you're being charged with, and what you can do about an attorney. And they'll talk about bail and issues such as that. But the arraignment is the first thing that happens. One of the things that happens at the arraignment is either the clerk or the judge will give you what's called a bail warning. Basically, they say that while you have an open case in Massachusetts, if you get rearrested, if you commit any other charges, if you get picked up on anything, or if you commit any other crimes, your bail can be revoked on the open case, and for up to 90 days. So that means that if you have an open case, that if you get charged with a new matter, or if they believe that you've committed a new offense, they can hold you in jail for up to that time, for up to 90 days, or until your case is disposed of. So what happens is there are three things that the Commonwealth, that is the prosecution, needs to show at a bail revocation hearing. So typically, what happens is someone goes in, they get arraigned, the case is going on, and they pick up a new charge. So the Commonwealth will next time next time you are brought in, the Commonwealth will make a motion to revoke your bail. Now, even if you haven't had to pay cash bail to get out, you're still technically on bail because you have a condition of release to not commit any new offenses. So a lot of times people will tell us, well, they can't revoke my bail. I wasn't on bail on the old case anyway, because I was released on personal recognizance, or PR, or sometimes called ROR, released on recognizance. But that you're still considered to be on bail, even if you don't post any cash bail for these purposes. So the Commonwealth has to prove that you were given your bail warning. That's the way we just went over just a moment ago, they will alert you that if you get picked up, if you commit any new crimes, you could have your bail revoked. So they have to be able to show that you were given that warning. And typically they only have to show that there's on the docket, there's just a checkbox to say that the bail warning was given. If it's checked, you've been given your warnings. Sometimes there's a question as to whether or not the person was actually given that warning, and sometimes, hopefully, it's in the same court where they're trying to revoke your bail. You can perhaps get a copy of the recording from that particular day to see if indeed you were given your bail warning. So they have to show that the warning was given. Step number two is the Commonwealth has to show that there is probable cause to believe you committed a new crime. Now, you don't have to be charged with a new crime in order to have your bail revoked on the old case. However, that's usually what we see. Although technically, even the Commonwealth could even put on evidence to convince the judge that there's probable cause to believe that you committed a new crime, even if you haven't been charged yet. But that's a very rare case. Personally, I've actually never seen it, although I know that it's technically possible. So they have to show that there's probable cause to believe that you committed a new crime, and being charged with a new crime, the basis for charging you with a new crime is that there's probable cause to believe that you committed that crime. Therefore, if you've been charged with a crime, probable cause is very easy to find. And the third thing that the Commonwealth has to show is that releasing you into the community would be a danger to the community or to a member of the community. So that means typically, if you pick up a new charge, if it's a serious charge, you're more than likely will be held. They'll revoke your bail and hold you. But if it's a charge that's not of a very serious nature, let's say it's a driving on a suspended license case, if there's no other terrible facts about that, a judge probably would not revoke your bail on such a case. And typically the prosecution won't be looking to revoke your bail if you pick up a new charge such as a traffic violation. So those are the three things that the Commonwealth has to prove in order to revoke your bail. And again, if they revoke your bail, You have no other, there are no appeals, there's no way to bail out. They will hold you in custody until the conclusion of your case or up to 90 days. And in the time now, in the time of COVID, that's even been extended, so the 90 days doesn't even count. So that clock can keep on ticking. So you could find yourself behind bars for a significant amount of time. Well, 90 days is a significant amount of time. One day would be a significant amount of time, in my opinion. So that's a bail revocation. We see it. It's very frequently done in the district courts. It's something you want to be aware of. If you have an open case, you have to be extra careful not to get into any other trouble, because they will move to revoke your bail and to hold you in custody. So again, I am from Afford Law. We provide experienced legal representation in criminal law and family law matters throughout Massachusetts. Our fees are all based on a sliding scale based on your income. So the less you make, the less you have to pay for our services. We have a lot of experienced attorneys that we use, and those attorneys know what they're doing, and they'd be happy to help you out. These folks are dedicated to providing services to people who would otherwise have to represent themselves, God forbid, especially in a criminal case or a family law case. So please keep us in mind if you're looking for an attorney and you want to see if you qualify for our reduced rates. We ask you to go on our website of affordlaw.org, see if you qualify for the reduced rates. Please feel free to book a free virtual appointment, no obligation. We'd be happy to answer any questions that you might have. At Afford Law, we're making justice affordable. Thank you.